Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about lay opinions. Cases that should have gone to the Supreme Court of Canada, but didn't. In the case of Mr. Toth, he was charged with manslaughter after a fight outside a bar. A bouncer at the bar witnessed the fight and saw that Mr. Toth had pushed the victim in the case on 2 occasions. The first push, the bouncer said, was justified, but the second push was more than was necessary and amounted to ultimately manslaughter when the person who was pushed fell and hit their head and fatally struck their head as a result. And this case raises very important issues. When the Supreme Court of Canada declined to hear it, they failed to consider the significance of lay opinion, particularly when it comes to physical interactions. We see a lot more now armchair quarterbacking of people's interactions because of social media, because so many incidents are recorded and able to be analyzed almost in real time by people who consider themselves to be experts. And the more people are exposed to other lay opinions on the internet or through social media platforms about how an investigation or an incident or an altercation has transpired, the more it is likely that their opinion is going to be tainted by information that they've seen in other sources, as opposed to the legitimate circumstances of the case. And so lay opinion really needs to be requalified as a result of this day and age of social media and instant commentary and the armchair analysis that people who don't have any qualification to give them do, especially because anybody can hold themselves out on the internet as having expertise in a particular area, even if they don't. It would be important for the Supreme Court of Canada to revisit the analysis that needs to be done on lay opinion to take into account the more nuanced cultural factors that we now have in our society. And it's unfortunate that we didn't see the Supreme Court of Canada take this opportunity to revisit the question of the degree of admissibility that lay opinion evidence has and the weight that it can be given in light of these changed circumstances. Hopefully they have another case to hear that soon so that we can see the way in which social media evidence and lay opinion impacts our court proceedings. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.